apology note to me if you don't accept this. And that's when I just
that is
shut up and listen.
not true, and I can play the video.
Gentlemen.
All I can tell you is that we're here because of the 500-page demand. I loathe bullying, Your Honor. We're living in a very strange moment in time where it seems to become more and more acceptable. I refuse to accept it.
Nowitzki, you are Mr. Nowitzki, sir?
Yes, I am.
And Officer Hadrinos, can you simply identify yourself on behalf of the people?
Yes, Your Honor, Officer Hadrinos.
Thank you very much. The record should reflect that this matter is before the court on an impeding traffic citation, which the parties are likely aware is a 0-point non-moving violation. The record should also reflect that there has already been a $175 bond posted. So the court's going to explain the procedure real briefly. Mr. Nowitzki, this is an informal hearing. It's a non-criminal proceeding. Nobody goes to jail today on this ticket, but it's considered serious enough that Officer Hadrinos did in fact issue the citation on the date in question. And that date was September the 8th of this year at 12 minutes past 10 in the morning. It is said you were operating a 2013 Buick, red in color, on 13 Mile Road at or near Campbell in the city of Royal Oak. And at that place and time, in some form or fashion, you impeded traffic. Officer Hadrinos' note, which appears on your ticket, indicates eastbound 13 Mile made prohibited turn at Campbell, posted no left turn due to the construction, which was fairly infamous at that period of time. So what the officer did do, Mr. Nowitzki, is on the roadway, rather than issuing a citation for disobeyed traffic control device, which is a 2-point violation, he chose within his discretion as permitted to him by command staff at the Royal Oak Police Department to issue the 0-point non-moving violation of impeding traffic. Notwithstanding any of that, today's your day in court. So you do have 3 options to protect your rights. You may admit responsibility in this matter. The court would simply hang on to the $175 bond posted, and that would close the case. You may admit responsibility with an explanation that you believe further mitigates your circumstances. Your third option is to deny responsibility. That is your right and your privilege. If you do so, the court would swear both parties under oath. The officer would testify first. They have the burden of proof today. Then it would be your turn to testify. Tell the court what you wish the court to know, and then the court would make a finding of responsible or not responsible. But please understand, because we are in civil court and not in criminal court, the burden of proof is a mere preponderance of the evidence, otherwise known as the featherweight test. So, as to impeding traffic in some form or...
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What starts as a simple 0-point traffic ticket in Royal Oak quickly spirals into allegations of bullying, a supposed 500-page apology letter, and a credibility battle between a citizen and a police officer. On paper, it's minor. In reality, it's a clash over authority, discretion, and whether this was a fair break or a power move gone wrong. And here's the twist. What began as a reduced charge might now escalate back to a more serious violation. So ask yourself, would you fight a $175 ticket on principle, even if it risked making things worse? Let's watch this unfold.
Fashion, do you wish to admit and explain, or deny responsibility?
I want to deny.
Very well. Please raise your right hands, gentlemen. You solemnly swear the testimony you shall give before this court shall be the truth.
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. The officer has the burden of proof. Mr. Nowitzki, then it'll be your turn. Officer Hadrinos.
Your Honor, on the date in question, September 8th, 2025, approximately 10:12 in the morning, I was parked on Windermere, which is one street north of 13 Mile off of Campbell. So I was on the west side. observing traffic for this intersection because there was a construction on 13 Mile. It was posted very clearly, no left turn from eastbound 13 Mile to northbound Campbell. I was sitting there observing the intersection. I observed Mr. Nowitzki's vehicle make that prohibited left turn. I stopped him on Millard Street, spoke with him. He stated he did not see the sign. He was very polite. I looked at his record. He had good driving record, so I gave him a break at the scene with impeding traffic. However, at this point, it should be amended back.
This is where things get strategic. The officer admits he initially used discretion, downgrading what could have been a 2-point violation to a 0-point non-moving citation. That's significant. In traffic court, points affect insurance rates and driving records, so that break mattered. But now, he's asking to amend it back to the more serious charge. That's a legal escalation. And here's the tension. When you contest a reduced ticket, you risk losing the benefit of that discretion. So the question becomes, was fighting this worth the gamble? Or did pride just turn a warning level offense into something bigger?
To the prohibited turn now.
The court can consider any motions relative to this matter after receiving the testimony from both parties. And is there anything further, Officer Hadrinos, you wish the court to know?
No, Your Honor.
All right. You obviously have the right to rebuttal if you choose to use it. And we turn to Mr. Nowitzki. Mr. Nowitzki, what would you like to tell the court?
Good story. I was proceeding eastbound on 13 Mile. It's 5 lanes. It was reduced to 2. 3 lanes in the middle were being resurfaced. And so the sign that the officer suggested was posted 5 lanes north. He was out of the cone of vision. I sent you some photographs of this, Your Honor. It wasn't on the right-hand side. It wasn't on the left-hand side. It was 4 lanes left. Okay, I'm sorry. I don't know how loud my voice is. I can turn this down if you want me to.
Oh, no, it's not that. The court's been in court long enough to know that you obviously have some strong feelings about this, but the court just simply wants this matter to remain fair, square, and gentlemanly. So the court is now reviewing some of these photographs that were mailed to the court plus or minus September 16th of 2025. So you may continue, Mr. Nowitzki. Please continue.
Thank you. I took a very prudent turn, not imprudent. It was very slow and cautious. There was no cars coming westbound, 0 cars coming westbound. There was 0 cars in back of me for at least a half a mile. With very, very light traffic. There was 1 car parked in the intersection with his left turn signal on, going southbound on Campbell, without any postings, without any lights indicating no left turn. I assumed that taking the same left turn in the same intersection with 3 lanes being available to park for traffic to clear was a prudent decision. Your Honor, it was not in clear, visible lanes. Now, here's why we're here. When we got to Millard, I did, in fact, say exactly what I just said. That was a very prudent turn. It wasn't visibly posted. I felt it was a speed trap. I saw the Royal Oak officer parked in Madison Heights, I believe, not Royal Oak. And so I asked him, is this normal? Is this all? It didn't feel normal. It felt like entrapment, if I may use a word without being a lawyer. And he said, Mr. Nowitzki, I'm going to cut you a break. And he described what he thought it was a break. And I said, wait a second. You're making this whole thing up. Wait a minute. This whole thing is being fabricated here for God knows what reasons. I don't know. I said, look at my record. I'm a very prudent driver. I don't. And he said, listen, if you don't calm down here. And I wasn't aggressive. I'm just as animated as I probably am right now, Your Honor. And he said, and this is why we're here. I could make you write a 500-page apology note to me if you don't accept this. And that's when I just
That is
shut up and
absolutely
listen.
not true, and I can play the
So,
video.
Gentlemen.
Emotional core of this case, a 500-page apology letter? That's not standard police procedure. That's a serious allegation. If true, it suggests intimidation. If false, it's a direct attack on the officer's integrity. Notice how quickly the courtroom temperature rises. The judge immediately reins it back in because now we're no longer debating signage, we're debating credibility. And in civil hearings like this, credibility can outweigh technicalities. There's no jury. It's one judge weighing who seems more believable under oath. So who do you think carries more weight here? The officer with video he can't access, or the driver standing on principle?
That is an absolute lie.
Officer Hadrinos, you will have the opportunity to make rebuttal testimony at the appropriate time. But we have to, even though it's an informal hearing, we have to follow the rules of procedure as closely as we can so that we have a clear record in case this matter somehow finds itself before the chief judge on some form of an appeal. So, Mr. Nowitzki, if you can continue.
Well,
Do you have
that's
anything else?
all I can tell you is that we're here because of the 500-page demand. I loathe bullying, Your Honor. We're living in a very strange moment in time where it seems to become more and more acceptable. I refuse to accept it. We're here because of that exact statement, Your Honor. In good faith, I already gave you the check. It's not about the money. It's about making it up and then threatening me with authority that I don't perceive an officer has. And that's why we're here. And if we have to go to another court and get an attorney to represent this, because I'm telling you the gospel here, Your Honor, if I have to go someplace else, I will. I refuse to sit back and let this guy bully me or anybody else. And if that's what we have to do here, let's do it. I'm not afraid to go anywhere else. I'm not afraid to hire an attorney. I refuse to be bullied for something that I didn't do. Thank you.
Thank you. Rebuttal testimony, Officer Hadrinos.
Well, I'm trying to bring up the Axon video, but I just got locked out of my account. But that's an absolute lie. That's not anything that I use. I don't say anything like that. Mr. Nowitzki is absolutely lying. If I could bring up the video, I would show you. Can you look at evidence.com, Your Honor, there, or do I have to bring it up and share it?
Honestly,
Because I'll bring up the
3.5
body
years,
cam because
I
that
have
is an
not done that.
absolute lie.
If that's going to take you a minute, which is fine, here's what the court can do. We can just take a brief adjournment. If it's just going to take you a minute or two to get back into that, that's fine with the court, because the court wants each party to have ample opportunity to make their statements to the court in full. So why don't we just break for a couple of minutes and you can continue working on that. Thank you.
Thank you.
Officer Hadrinos, how's it going?
Apparently, administrator has to unlock it, and none are here right now.
Okay. All right. Without the view of the video, you already indicated that you believe Mr. Nowitzki was not being truthful with respect to the remark about something about a 500-page apology letter.
Well, that's
this
one.
is your.
That's one. The first
Go on.
one was that it wasn't clearly marked. I don't know when his pictures were taken, but I when I sit on those intersections, I make it a point to drive the way that the signs show so that I can view and make sure that they are properly marked. And that was properly marked so that I could sit there and write an appropriate ticket. And then secondly, yes, that is a bold-faced lie that I told him he could write a 500-page essay or word essay or whatever apologizing to me. That is not anything that I would ever say.
All right.
And I'm sure the video will show.
Thank you. So that the record is as plain as it can be. What the court intends to do right now, and the court hopes you can see, is
I'd like
this
an
is actually
adjournment then.
this is actually Mr. Nowitzki's exhibit, and if
There's
that
the sign.
right, okay. So, can you describe for the court what you're seeing and whether that comports with what you saw in person that day, Officer Hadrinos?
Well, I can't specifically say that that's exactly what I saw that day, but that sign is at the end of the intersection, right at where you would see it as you're driving. And then if you look, the left-hand turn signal is also blocked out with black covering.
So what the court wants the record to reflect, if it is so, is that this is the view eastbound on 13 Mile Road at Campbell, as you recall it, with the same physical features and barricades. Is that correct?
Yes, I can't speak for exact placement of the left turn sign, but it's still, that picture still clearly shows that, yes, at that intersection, you cannot make a left turn.
Okay. And is there any further rebuttal testimony?
Well, I'd rather you adjourn this now and bring it to another date so that I can show the video of, because
Okay.
I'm not going to let stand his accusations that I bullied him. I obviously was very cordial with him because I gave him a break. If that was the case, if I was bullying him, I wouldn't have given him a break. I would have given him the full citation.
What the court is going to do at this time is grant a motion to adjourn without adjudication. So the court is not making a ruling at this time. The bond remains in the court's escrow fund, and the court will indicate motion to adjourn without adjudication. The court can't tell you two gentlemen whether or not it'll be in front of Judge Kowalkowski or Judge Meineke, but at that point, obviously, the city attorney would be represented by City Prosecutor Ryan Kaluzny. So as of today, the testimony has been received, but there is no ruling. The matter is adjourned to the formal hearing docket.
And just like that, no verdict. The judge adjourns without adjudication, meaning no one wins, no one loses, yet. The bond stays put, the testimony is preserved, and this could move to a formal hearing where a city prosecutor steps in. That raises the stakes significantly. What began as a 0-point traffic issue now sits on a path toward a fully litigated dispute over signage, discretion, and alleged misconduct. The big takeaway? In court, tone, credibility, and strategy matter just as much as the underlying violation. Sometimes, fighting on principle carries consequences far beyond the original ticket. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you very much for your patience.
Thank you, Your Honor.
We're going to begin today by taking up this case, People of the State of Michigan versus Kelsey Jacqueline Sim. We are here today for a sentencing in this case.
This was a difficult case, Judge, insofar as, in my interactions with Miss Sims, she's been focused on rehabilitation. Unfortunately, Mr. Blazak report does accurately summarize some of her conduct while out on bond, while attempting the rehabilitation. And unfortunately, I think the court is probably too familiar for its own liking in terms of the ebb and flows of people that battle addiction. Talking to her recently in preparation for today's hearing, she remains focused on that. She's once again made contact with the Sunrise Center. She does inform me she's serving a separate sentence for some misdemeanor offenses through Wexford County. Her release date is February 8th, 2026 on those offenses. She's hopeful that she will have an opportunity to re-engage in rehabilitative substance abuse services through Sunrise Center. I'll just say that she's been very cooperative with members of law enforcement since she's been detained in the local jail on some other matters. My understanding is that cooperation was appreciated. And regardless, ultimately, she understands that, she's got a checkered past. This is now an additional felony conviction. And anytime you start trending towards a total, more or less hit count, if you will, approaching 20 prior convictions, that's certainly concerning in terms of her ability to remain free should there be additional contacts with the criminal justice system, certainly in the felony land, as her guidelines would go clearly away from any type of presumptive no jail sentence, to perhaps consider keeping her there or thereabouts with her current release date of February 8th, 2026. Thank you, Judge.
Mr. Diego, she mentioned that there were some other issues that she's had over in Wexford County. Did she enter pleas or something? Was that taken care of in the district court over there?
My understanding is yes, Your Honor. She is currently serving time for a malicious destruction of property charge and perhaps an attempted R&O as well.
All right, thank you. Mr. Denhouse.
Thank you, Your Honor. The underlying incident occurred back in December of last year. The defendant wasn't on supervision at the time. There was a compliance check, and she was found with some narcotics.
It was not.
It's a tramadol.
Right. He just said that I was on supervision, and I was.
Oh, I'm sorry.
I was at somebody's home who was on supervision.
I got it.
I'm sorry for
It's okay.
interrupting.
Okay.
I think it's all right. Go ahead.
I'm so
I
sorry.
appreciate it. It was a compliance check. I perhaps misspoke for another individual, so I apologize for that.
It was Mr. Ealing.
In any event, I accept the correction.
Which, by the way, Mr. Blazak, when you put in a person's name right after their address, if their address ends with the word drive and you just put DR, it looks like you're saying that Mr. Ealing is Dr. Robert Ealing. I had to keep shaking my head. I'm like, I'm pretty sure I've never heard of him as a doctor. All right, go ahead.
We would never penalize someone for exercising all of their rights and contesting all matters. We would never consider doing that. But to the defendant's benefit, she acknowledged that she did have narcotics. She pled guilty. Also, when the bond violations came out, she also acknowledged the difficulty that she's been having. So I think that can be stated on her behalf. She has been struggling. There has been a series of bond violations. I know the recommendation now is for a straight jail sentence. We understand the reasoning why that recommendation exists. We support that recommendation, and we would leave it to the court for the exact term of any additional incarceration.
All right, thank you. Ms. Sins, you have the right to make a statement if you so choose before the court issues a sentence. Is there anything you wish to say today, ma'am?
Your Honor, I would just like to say that your mercy was not extended in vain. I did happen to, I had 1 week left of treatment, and I got into a verbal argument, which caused me to be released from the treatment. I managed to stay clean. I'm clean to this day. I did not indulge back in drugs. I started going to a revival center and became part of the celibate recovery. I maintain a job now. I also have been going to church occasionally with the owners there who are part of First Presbyterian in Cadillac. So I did make some significant changes, although I do take accountability for you extending that mercy to me and me failing. Like that was, I still hold that as a reminder in my head today that, I don't want you to think that your mercy was extended in vain. I'm just grateful for your time today, and I do take accountability, and I accept whatever punishment you see fit.
Thank you. I don't want to forget it. The one comment you made, nothing about today is personal with me. All right. I understand that addiction is a difficult problem and challenge for people. Nothing about this is about me today. Now, the next thing I want to talk about is, and I don't mean to do this in a rude way, Mr. Blazak, there's something wrong with this report. There's a lot wrong with it. All right. So I'm going to walk through it, and I'm just going to ask you some rhetorical questions. A little bit like Socrates here, although I wear a white robe or a black robe. Substance use and treatment. It now says no substance abuse history found for the defendant. So now I start scratching my head wondering, well, geez, why wasn't there a list of drugs on CFJ 145 page 1? And then I wonder, why does the Compass score and comments talk about her having a drug abuse problem And then I get back to this page and it says, well, she doesn't have a drug abuse problem. And then I wonder, well, then I go to look at her criminal history. In 2013, she had a conviction for morphine. In 2016, she had a conviction for fentanyl. And in 2018, she had a conviction for meth. Especially when somebody has been gone for 5 months, you need to do an updated PSI, because it also doesn't include the fact now that I know she's got other convictions while she's been on my bond. The sentence I wrote down, the sentencing and the story told here are incomplete and inconsistent. Is why would I, or this court or any court, send her and allow her to do rehab and then find out she violates rehab, and to find out she needs rehab when the report, half of it makes it sound like she has no drug problem or drug history. So there's a lot here that this report is not done well, and it needs to be updated. Now, Ms. Sims, we've already talked a little bit or talked around it. Your performance on bonds has not been good, and you have left programming when the court lets you go there. When again, you talked about it being grace, and I appreciate that. That's what it is. It's a grace to allow a person the chance to go prove themselves. Well, in here, you were removed from one program. You revoked your waiver so community corrections couldn't find out where you were or what you were doing. And you failed to keep community corrections informed of your whereabouts. And you were not cooperating well with your PSI, which may contribute to the inaccuracy of the report. So let's take a look here at the crime. The crime was relatively minor. You had, it looks like, a pill or two of the tramadol, and you called it medication for your dog. I don't believe that's what it was. I don't know of many dogs getting prescribed tramadol, but the fact is, if you want to take that, then my thought is, well, then your problem, your substance abuse issue is so strong that you're willing to take dog medication. But we all know that tramadol is often used for adults in certain circumstances. So then I looked at the history. Back in 2008, she had a juvenile, in 2004, a juvenile history, adjudication 2007. And that was, you were discharged on April 15th of 2008, and you made it a little over about a year and a half before you started picking up charges as an adult. Between your 2009 conviction, actually you had two of them, and they were 1 month apart. In November of 2009, while you were on bond for one of the previous ones, you picked up a conviction. And it looks like you had paid all your fines and costs in that case, and there was an active warrant for you out of Manistee. Well, when that case was done in August 10th of 2010, you were back in front of a court within 2 months. No, that's one bond violation, failure to appear. And then you had 1, 2, 3, 4 different probation violations. In fact, when you were sentenced on April 6th of 2011, you were back in trouble in 2 weeks. Then between entry 5 and 6 of 15, you did have a gap of 2 years, and that's where we saw the morphine come in. And then probation was revoked in that file because you were violating probation quite quickly. Then, after being off of probation for 4 months, you picked up number 7 of 15. While it's just a driving license suspended, I tend to take those and say, well, this is a sign that a person will do what they want as long as they think they're not going to get caught. Well, you made it about a year, picked up a retail fraud, and 8 of 15. Then for 9 of 15, you were back in trouble about a year later. 3 months into that probation, you picked up a home invasion, which was apparently pled down to a domestic violence. So you got repetitive acts of violence in your history. Looks like you made it about a little over a year before you picked up this case. And as we know, on it, you violated bond and picked up new charges. But when the court allows somebody to go to rehab, it does so because it cares and wants to give rehab. But I also do it to see how people behave and whether or not they're going to continue their previous patterns. That's a problem. So what I see here is 20 years of the same types of almost 20 years of the same kinds of problems: violating bond, violating probation, acts involving drugs, acts involving crimes of dishonesty, acts involving violence. Well, in this case, the court assesses the standard $68 state minimum fee, $130 crime victims' right claim fee, a $300 court cost, a $500 fine, a $300 attorney fee. DNA was already available. There will not be any supervision. So there's no supervision fees. And the court sentences the defendant to a jail term at the top of the guidelines, which is 330 days with 35 days of credit. I do so because I've already covered all the reasonable grounds. Every opportunity or grace is provided to you, and you've thwarted them over and over and over again. So, nope, it's all right. That's the sentence. There's nothing you're going to say that's going to make it better.
Just a note to that, another to continue to stronghold my treatment.
Yeah, well, they have people who come to the jail. You're not going to be placed on probation. You're telling court, just as Mr. Nago said, you're at that level where next time you're looking at presumptive prison cells on felons, at least for drug charges. And you've had the opportunities and you rejected them. And it's your issue, not mine. This has nothing to do with this court. That's the sentence of the court. Have I missed anything, Mr. Blazak?
Is that like at work really?
Oh, we don't do that. Mr. Deno? Madam Clerk is going to bring out to you, ma'am, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt to the copy of the document. This document tells you that you have the right to file an appeal in your case. Based upon the plea, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Any questions, Mr. Niegos?
No, Your Honor.
All right. Thank you all very much. Ms. Sims, I do want you to use your time effectively. I'm hoping that the words I choose, not that everybody pays attention to them, sink in. You're at that level now where there is nobody else.
Tramadol, so
I'm sorry?
it just upsets me because it's for my dead dog's tramadol. I'm getting the county.
No, hold on.
Yeah,
You're not.
that's upsetting.
Just a second.
I don't even have it in my possession because of my past history from 12 plus years ago. That's what's upsetting.
Yeah.
I'm losing my job. I'm going to lose everything
Because of what?
because of my past history.
Yeah.
People change. People change, Your Honor. And I have changed. A past history, the fentanyl charge wasn't even a fentanyl charge. I got larceny in a building. This is for past history. And I had my dead dog's tramadol. I don't even know how it's illegal for me to have a prescription of my dead dogs anyways. This whole thing makes no sense to me. I'm just in shock right now.
Okay. I understand that you're just in shock. But this is not just because of your past history. This is because your pattern. And because in your pattern, you've continued to demonstrate. You continue to violate bond. You continue to violate all.
Somebody account me a year.
You're going to let me talk. Okay, hold on.
I don't really, I mean, at this point in time, it don't matter anymore. It doesn't matter anymore. You made your decision and it doesn't matter. You just ruined my life. I was starting to do good. I was starting to have a good job. I had a good support system behind me and all that is gone now. So it was like, what was the point? What was the point of me trying to change? This is why people don't change, because when they do, things like this happen.
We're very calm today, which is something I'm working on. Every judge has to work on it, and that's okay. If you want to blame me, Miss Sims, that is perfectly okay. It's directed in the wrong direction. No, nope, stop.
You don't care, I know.
You may leave because I'm about to add 60 more days to your sentence. We're adjourned.